By hook or by crook seems to be the sentiment of some who promote abortion in this country. When they could not get their way by federal law, they engaged in the federal judiciary. When the judiciary abandoned them, they went back to using state law to get their way. And when state law didn't get them all they wanted, they used regulation to backdoor themselves around the law. Well, such seems to be the case in California. So we'll discuss that next on the Constitution Study. Hello there, everyday Americans. Welcome to the Constitution Study. Paul Engel here. This is where we read and study the Constitution. We teach the rising generation to be free, and I am glad you could join me today. You know, there's a lot going on with the Constitution Study right now. Yes, I'm out on my tour. If you want to find out more about the Blessings of Liberty tour, just go to constitutionstudy.com/tour. I'll talk a bit more about that and some other things at the end of the episode, but for now, let's talk about California and abortion regulations. In 2014, the California Department of Managed Healthcare, known as the DMHC, sent letters to several private health insurers directing them that they remove any limitation or exclusions regarding abortion care services from their healthcare coverage. It seems that the agency had approved plans with such limitations, which the DMHC's director believed to be in error. Several churches, including Foothill Church, Calvary Chapel, Chino Hills, and Shepherd of the Hills Church, after receiving the director's letter, asked if they could receive exemptions as religious organizations. They requested health care insurance coverage that did not cover all legal abortions. Specifically, they requested that their policies either exclude abortions or only cover abortions where the pregnancy unquestionably threatens the life of the mother. Now, they were told by two different insurers that they understood the DMHC letter to preclude even religious exemptions. This was incorrect, however. The DMHC had previously determined that religious employers could legally restrict abortion coverage consistent with their beliefs. The DMHC would later approve a request to exclude abortion care services from religious employers, except when the abortion was necessary to save the life of the mother. However, these churches were unable to secure coverage that aligned with their beliefs, leading to the case in the federal district court, Foothill Church et al. Versus Mary Watanabe in her official capacity as director of the California Department of Managed Healthcare, which I'll refer to as Foothill Church versus Watanabe. After nearly 3 years of litigation, the churches requested a religious exemption from DMHC. Now, California's Attorney General stated that DMHC could only consider granting exemptions to healthcare plans, not employers or other plan customers. As of the issuing of the court order in Foothill Church versus Watanabe, no plan had asked for approval for an exemption from abortion coverage from the DMHC. Now, in 2019, the District Court for the Eastern District of California dismissed the church's claims. The Ninth Circuit affirmed the District Court's dismissal of the Establishment Clause claim, but sent the case back to consider the plaintiff's free exercise and equal protection claims. Now, the court has reviewed the case, including the additional amicus or third-party brief from the California Catholic Conference. Let's look at the two claims separately, starting with the free exercise claim. The free exercise clause of the First Amendment, which applies to the states through the 14th Amendment, provides that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. However, the right to freely exercise one's religion does not relieve an individual of the obligation to comply with a valid and neutral law of general applicability on the ground that the law proscribes or prescribes conduct that his religion prescribes or proscribes. I know, Congress did not make this law, but the courts have been ignoring that little fact for decades. Even looking at the section of the First Amendment being quoted shows the problems with the court's interpretation. The Constitution says Congress, which the courts have extended to all governments, shall make no law prohibiting the free exercise of religion. Yet here the court says that that's not entirely true. The court claims, based on previous opinions from the Supreme Court, that your right to freely exercise your religion does not relieve an individual of the obligation to comply with a valid and neutral law of general applicability on the ground that the law proscribes or prescribes conduct that his religion prescribes or proscribes. Doesn't that mean that the government can coerce you into violating your religious belief as long as the law was neutral and generally applicable? Now, don't give up on this judge quite yet, though. A law is not generally applicable if it invites the government to consider the particular reasons for a person's conduct by providing a mechanism for individualized exemptions. Nor is it generally applicable if it includes a formal system of entirely discretionary exceptions. A valid and neutral law of general applicability must be upheld if it is rationally related to a legitimate government purpose. In contrast, laws that are not neutral and are not generally applicable are subject to strict scrutiny. Under strict scrutiny, laws must be justified by a compelling government interest and must be narrowly tailored to advance that interest. If you followed the Constitution study for any time, you shouldn't be surprised that the question of scrutiny would come up in this case. Like most federal courts, rather than following the supreme law of the land, their standard seems focused on allowing government to meddle where the law does not allow. Now, this is most easily shown by the standard of judicial review, or scrutiny, the court assigns to a case. In U.S. constitutional law, when a court finds that a law infringes on a fundamental constitutional right, it may apply the strict scrutiny standard to nevertheless hold the law or policy constitutionally valid if the government can demonstrate in court that the law or regulation is necessary to achieve a compelling state interest. Notice, scrutiny, also known as standards of judicial review, is not based in the Constitution of the United States, but in constitutional law, which is nothing more than the opinion of judges about the Constitution. So whenever you hear the term scrutiny in a legal case, understand that what the court is doing is deciding how hard the government must work in order for the court to allow it to infringe on your rights. In this case, the judge says the claims are subject to strict scrutiny, which is the highest level of effort the government must show to violate the Constitution. Getting back to the case and the free exercise claim, the churches argue that mere creation of a formal mechanism for granting exceptions renders a policy not generally applicable, regardless of whether any exceptions have been given, and thus challenge the state's decision to enforce the abortion coverage requirement against the church's health care plans in the first place. The director argues the churches are challenging her refusal to extend an exemption to plaintiffs because they are not entities subject to regulation by DMHC under the Knox-Knee Act. In other words, the churches argue the director would not extend a religious exemption to them, while the director claims she did not because she could not. Seems like a bit of he said, she said, doesn't it? Not really. Nonetheless, as the court was careful to confirm at the hearing, the director now concedes that the existence of a system of individual exemptions in the Knox-Knee Act subjects her decision not to expand the plan exemption framework to the churches to strict scrutiny. Accordingly, the court must decide whether this policy advances interests of the highest order and is narrowly tailored to achieve those interests. Now, everyone in this case agrees that the law under which the director of DMHC acted is subject to strict scrutiny. That means the court, and specifically this judge, will determine if the interests advanced by the law are sufficient to deny the people of California their rights protected under the Constitution. Does anyone else see how insidious this is? You have a government actor, the judge, determining whether or not a government's interest is sufficient to infringe on your rights. This is exactly what the Bill of Rights was created to prevent. While all parties in the case agree that the state needs to meet the highest burden of proof that they can infringe on your rights, the state still needs to make that case. Director explains her decision not to make an exemption at the church's request by citing her policy not to entertain requests for exemptions unless they come from a plan. She cites 3 compelling government interests. So the director of DMHC gives 3 reasons why the state should be allowed to infringe on the rights of these churches and their members. I want to look at them individually. First, the policy prevents a flood of exemption requests from over 26 million enrollees who may object to their plan's covered care services. Look at the very first concern the director brings up. She does not seem concerned with the impact on the people or the infringement on their rights, but how much work it will make for her and her department. Think of the arrogance that shows. In the meantime, you should be forced to support the murder of unborn children because Allowing you an exemption might make too much work for her department. Second, it prevents significant third-party harm to enrollees, which may occur if employers opt out of legally mandated health care coverage. Now, I'm not an expert in the California Constitution, but I am pretty sure the mandate the director is referring to is not legal. Did the citizens of California delegate to their government the authority to regulate health care coverage? A quick search of the state's constitution showed, notwithstanding any other provision of this constitution or existing law, a person elected to or serving in the legislature on or after November 1st, 1990, shall participate in the federal Social Security Retirement Disability Health Insurance Program, and the state shall pay only the employer's share of the contribution necessary to such participation. Beyond the members of the legislature, I could find no power delegated by the people to the state of California to place requirements on their health care coverage. Furthermore, by mandating that citizens of California purchase health care that meets certain requirements, they are depriving them of the liberty to choose a plan that best meets their needs and their beliefs. This violates the Due Process Clause of the Constitutions of both California and the United States. From California, we read, persons may not twice be put in jeopardy for the same offense, be compelled in a criminal case to be a witness against themselves, or be deprived of life, liberty, or property without due process of law. And from the U.S. Constitution, no person shall be deprived of life, liberty, or property without due process of law. Now, the director's last argument is, third, it appropriately restricts DMHC's jurisdiction as authorized by California state legislature. The director seems more worried about the restrictions put in place by the legislature than the Constitution she took an oath to support. Now, thankfully, none of these arguments persuaded the judge. None of these interests are sufficiently compelling, nor is the department's rigid approach narrowly tailored. Now, what about the church's claim of a violation of the Equal Protection Clause? The Equal Protection Clause of the 14th Amendment prohibits a state from denying to any person within its jurisdiction the equal protection of the law, which essentially directs that all persons similarly situated should be treated alike. A viable equal protection claim must show that the defendant acted with an intent or purpose to discriminate against a plaintiff based on membership in a protected class. The question the judge is trying to answer is, did the director target these churches because they were religious organizations? In other words, was the director of DMHC attempting to discriminate against them? Here, the judge was not convinced. The court previously dismissed churches' Equal Protection Clause claim for two reasons. First, the churches did not allege facts giving rise to a reasonable inference that the director treated them differently than similarly situated persons and businesses. The court noted the challenge letters apply to plans, not purchasers, and do not make any classification with respect to the purchasers. Second, the churches did not allege facts showing that defendant acted at least in part because of, not merely in spite of, plaintiff's religious beliefs. The judge in this case split the decision. She granted summary judgment for the churches on their free exercise claim, but found for DMHC on the equal protection claim. The case, however, is not over. While this order is in place, the judge also ordered both parties to provide supplemental briefings. Now, while this case moves forward, and whether you live in California or not, I want you to consider this. The only reason the judge found for the churches is she did not believe the director made a sufficiently compelling case to infringe on the rights of these churches. Think about that for just a minute. Yes, the case was about the free exercise of religion, specifically whether or not churches could be forced to provide abortion coverage in their employees' health insurance. But the underlying jurisprudence came down to scrutiny and how hard government had to work to overrule the Constitution of the United States. Also, it seems the reason the judge granted judgment to the director on the Equal Protection Clause claim was because the state did not apply its rule to the churches directly, but got private third parties to do it for them. Is that what passes for justice in America today? Is this what people call the rule of law? The protection of your rights determined by a single judge? How safe do you feel when the protection of your rights comes down to how a judge feels about a compelling government interest? What about the compelling government interest laid down in the Declaration of Independence? That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. Doesn't the current abuse of judicial review, making the rights of people subject to government interest, turn the purpose of government upside down? Now, this was an interesting one because the case is still really early. I wasn't dealing with an opinion, but so much as some interim judicial review of the case. But I want you to notice what's going on here. California apparently didn't believe they could order churches or other private organizations to have certain products in their healthcare coverage. But they could order plans to only offer, but they could order insurers to only offer plans that provided the services they wanted. Kind of a backdoor way to make this happen. And the churches were arguing, listen, you are doing this because we are pro-life. We don't believe in abortion. They claimed it was purely religious, but you could see the linkage. And because you are pro-life, you're not allowed to be pro-life because, well, that kind of infringes on California's belief that abortion is necessary. They even go so far to say, listen, we won't even listen to your request for an exemption because it's got to come from the plan. Except the plan's not the one paying the bills. The plan is the one selling them. So it's an interesting situation. Again, it's California, so it's a bit convoluted. But hopefully you'll see the dangers of allowing governments to use third parties to enact policies that they're not allowed to enact directly. And one last thing. If California can do this, why not New York, Illinois, or Oklahoma for that matter? See, it's the underlying principle that I think here at the Constitution Study we want to focus on. It's not simply an abortion question. It's this idea of government saying, listen, we can infringe on your rights. We can overrule the Constitution if we can convince a judge we have a good enough reason. And that should scare any liberty-loving American. Now, hopefully you found this interesting. Head to the website, constitutionstudy.com. You can find the text of this article, the video, share it. Share it with friends, share it with family, share it on social media. Let other people know what's going on in California and that they can get this type of review at the Constitution Study. As I said at the beginning, I'm right now on the road on my first leg of my Blessings of Liberty tour. And if history is any tell, I'm having a lot of fun doing it. Now find out more at constitutionstudy.com/tour. Now I do not charge for any of these events. I don't charge to show up. We don't charge people to come to the event. We're doing it absolutely free. Now, some of these groups are actually getting me a hotel room, which I appreciate greatly, but there's more that we can do. So do me a favor. On that page, constitutionstudy.com/tour, you'll also find a donate button. Donate to the cause. Help me bring this message of the blessings of liberty to all of the United States. I'd love to be there in all 50 states, but I need help doing that. And if you can support me in doing that, I would appreciate it greatly. Hey, if you'd like me to come to a place near you, there's a form right there. Fill that out, and I'll see if I can come to your location. While I'm wrapping up the Northern Plains leg of the tour, I'm already making plans for other legs. So please find out more, fill it out, and let me know. Also, I've been adding some interesting merchandise, some new shirts to the website, constitutionstudy.com. Just go there and check out books and more. Hopefully you'll like one of the shirts and maybe you'll even pick one of those up. Whatever you do, please take this information, everything on the Constitution Study, all the articles, all the videos, all the analysis, I give to you for free. I ask only that you share it with others. Please do that. It helps others find about the Constitution. It helps others learn to read and study the Constitution, and it helps them to teach the rising generation to be free. And by sharing that, by becoming part of it, you become part of a team that is working to share the blessings of liberty, that is working to earn the trust that our predecessors have put in the American people to govern ourselves. And I think that's worth a little bit of time, a little bit of effort. And hey, if you like this program, bring some friends next time as we get together here at the Constitution Study.